Welcome, everyone. Before we start with the program, I'd like to go over some housekeeping matters with you. First of all, pursuant to Utah Supreme Court rules regarding CLE, you have to stay on for the entire 60 minutes in order to get credit. If, for some reason, you are booted off and you sign in using a different ID, different email or your phone, please email me at lori.nelson@law.utah.edu and give me both of the IDs you used to sign in so I can make sure you get credit. Second, if you did not put your bar number in when you registered, I will get the report for who attended. Please, everyone, don't email me with your bar numbers. I will email you if I don't have your bar number and if I can't find it independently. But in the future, remember to include your bar number when you register so we can make sure you get credit when we send the report to the bar. Second or third, let me remember all the things I'm trying to tell you. Third, for purposes of this session, if you want to ask a question, please put it in the Q&A, not in the chat. We're going to monitor the Q&A to make sure your questions get answered, but don't use the chat. That's not being monitored. And last, the PDF of the PowerPoint is under the Resources tab at the bottom of your screen. If you click on the Resources tab and then click on Documents, the PDF of the PowerPoint is in that section. If you can't find it, please email me and I will figure out a way to get you the PDF. Now for the program, I'm so pleased and grateful to our two presenters who are going to talk to you today about the intersection and possible conflicts that can arise between family law and estate planning law. Amy Kennedy will be talking about family law. Doug Fadel will be talking about estate planning. And Doug, I think we're going to start with you.
Oh, we're actually going to start with Amy.
Oh, see, surprise.
It's a test, Lori. Just
it is.
Good afternoon, everyone. When Doug and I were initially talking about this presentation, we were brainstorming ideas. We came up with about 20 different ways where family law and estate planning overlap. And obviously, we will not be able to get into all of that over an hour. So what we decided to do is really focus in on the things that estate planning attorneys really need to know about how family law most commonly interacts with their practice, and the same for family lawyers. As Lori said, please ask us questions. We will get to those. We're reserving a lot of time at the end of our discussions.
I do have one question. A question was presented to me a number of years ago about why, when you do a prenuptial agreement, there needs to be separate counsel for both the parties because their interests are inherently in conflict. But when you do an estate plan, you can represent both parties. So do you guys have any comments about that? Because many of the things addressed in both a prenuptial agreement and in an estate planning document are the same.
They are, and I know Doug is going to be starting off with that.
The relationships are a little different. With a prenuptial agreement, you're necessarily adversarial parties. With an estate plan, if you're adversarial parties and you have two different things in mind, one attorney can't represent both of them. But if parties come to you and they've agreed on how they're going to set up their plan, they might have very different things in mind, but as long as they agree that each one of them can do as they see fit, then you can have the parties consent to joint representation. When they do so, they waive their attorney-client privilege, and I tell my clients, anything one of you tells us, we have to tell the other person. So if you don't want your spouse to know something, don't tell me. And you have to inform them that if ever they do get into an argument, if they have a fight, that I can't take sides. I can't represent one party against the other when I've represented them jointly.
Well, great. Thanks. Now, Doug, take it away.
All right. Very good. So when we do an estate plan, we have different phases of planning. We have an initial consultation, an initial plan where we set things up, and then people, never pass away right after we set up a plan. So we have this period of maintenance, where we might make certain changes. And then we have a period of administration when someone becomes incapacitated or passes away. And there are times where we set things up for clients in order to accomplish their disability planning, their estate planning, their asset protection planning, business planning. We help them with estate tax issues. We help them with income tax issues. And we aren't really concerned when we're assisting them with what happens if they choose to divorce. And so a lot of the things that we set up, not with an idea of them ever separating, time passes, they get into a dispute, and then Amy's involved. So that's the intersection as I see it. What do you see, Amy, as the intersection between divorce and estate planning?
I see a lot of those same overlaps, but I also see that in divorce world that we may not always be thinking about what happens with an estate plan, or God forbid, one of the parties dies mid-process. And with a lot of work I do with marital agreements, also including the estate planning elements into those agreements as well, and not just focusing necessarily on what may or may not happen in a divorce or separation.
Probably a good place to start is to talk about what is a spouse who is married. Of course, that would include legal marriage, but it also might include marriages not solemnized. Utah doesn't have the terminology common law marriage, but they have a statute for recognizing a marriage not solemnized. If somebody is married, they're married until they're divorced or it's annulled. While there are legal separations, as far as the probate code goes, the legal separation does not terminate the relationship of married couples. Some clients will come to you and they will say, I'm no longer in this relationship. Sometimes they still have a good relationship with the other party, but they'll say that we don't act as married couples. Sometimes they come to you and say, I don't like my spouse. I want to try and change my estate plan. And they might have this conundrum. Do they stay married, live separate lives, update their estate plan to cut the other person out or to modify things? Or should they get a divorce? Can I live with getting a divorce if I have to split all my assets 50-50? If I might have to take on more debt than I would if I had just passed away? And do I really want to be paying alimony to somebody else if I was to divorce? But if I, stay married, then I can modify my estate plan. I can't completely cut out my spouse unless I have a prenuptial agreement in place, but I may be able to modify things in a way that I leave more assets to the people I want to, rather than to the spouse that I'm divorcing. Some people wonder, do they really need to update their estate plan when they have gone through a divorce? And Utah law has provided that if you were to divorce, and it's not a legal separation, it's either a divorce or an annulment, a termination of the marriage, then the estate plan is necessarily modified. Under Utah law, divorce would revoke someone's right to receive property. It revokes a fiduciary appointment. It severs joint tenancy, and it can terminate a beneficiary designation under life insurance. One thing to keep in mind is Utah law applies to state laws. It might be that assets that you have are governed by federal law. If you're a federal employee, or if you have a 401k plan, it's an ERISA plan, it might be governed by federal law. Well, Utah tried to make sure that divorce would terminate relationships under those statutes. They can't modify federal law, but they do give a cause of action for a former spouse to have to return property that they obtained pursuant to federal law. So if, for example, there's a beneficiary designation set up under a 401k and it's governed by an ERISA plan outside of the state of Utah, and someone was to divorce in the state of Utah, while all of their other beneficiary designations might have changed, under federal law, the 401k plan administrator might still recognize the former spouse as a pay on death beneficiary, and that person would be entitled to the funds. Utah law grants the ability to request those funds from the former spouse. There are some certain defaults under the probate code. So what if you didn't set up your estate plan? What are the defaults? Under Utah law, whether you're married or not, the default is always, if you wanted to set up your own plan, if you want to designate your own fiduciaries, you want to say where your assets go, you want to say how those assets would pass to other people, you have the right to do that. If you do not, then we get into the Utah default rules. And under the default rules, if you're married, your spouse has priority. Your spouse has a priority to act as a fiduciary, and they're entitled to certain inheritances, even if you try to omit them. When we are representing surviving spouses, and we have a deceased party who has either intentionally or unintentionally omitted a spouse, if we're representing the spouse, we want to try to represent our client to get the most money possible. And it might be that we need to look at what is the role of the spouse in the estate. When we are administering estates through probate, there's a pecking order of who gets paid first, and that pecking order can matter. It might be that your best argument is that the spouse is a creditor of the estate rather than the spouse is a spouse entitled to an intestate share or an elective share. There are different hats that a spouse would wear. The spouse can be a fiduciary. They would have a priority to be appointed as a personal representative under an estate. They have priority to be an agent under a power of attorney if the principal hasn't otherwise specified. A prenup can be used to waive the right of a party to ever be a fiduciary. A prenup can require that a spouse act as a fiduciary. Keep in mind that divorce would terminate the right of the spouse to serve as a fiduciary. And the domestic relation injunction does not specifically prohibit someone who is in the middle of a divorce from changing fiduciaries. Another hat that the spouse could wear is that of a creditor under the estate. These claims as a creditor would take priority over all other claims except for certain spousal allowances that are allowed. So if the spouse is able to establish that they're a creditor for any reason, so if there's a contract between the parties, if in a prenuptial agreement, the decedent had promised certain things would be provided to the surviving spouse, those would take priority over everything except for the family allowance, the homestead allowance, and the exempt property allowance. These are small amounts that a surviving spouse would be entitled to against any other claimants. And these dollar amounts that I've included are indexed for inflation. These amounts would be reduced if the spouse was entitled to an elective share, has already received things through the will or trust. They receive something through intestate succession, through joint tenancy with right of survivor or POD, on pay on death beneficiary designation. So these elections can be made against the estate, but if they've already received that much money elsewhere, then they abate to the extent you've already received those funds. A prenup may waive these statutory claims, and it's very common for us to include in a prenuptial agreement a provision, particularly for older people who've had marriages from before and they've had children from before and they want to keep their assets separate. We often will include provisions where one spouse waives the statutory claims, the homestead allowance, family allowance, exempt property allowance, elective share, in the event of death. Oftentimes younger people don't do that if they're not as focused on the marital assets. They're more focused on keeping inheritances separate. They may not be as focused on not allowing someone to claim these statutory allowances. Divorce would terminate these statutory allowances. The spouse can be a creditor. So the spouse might pay for a funeral and they'd be entitled to be reimbursed. They might have paid for some of the expenses associated with administering the estate out of their own pocket. They can be reimbursed. They might choose to take a personal representative's fee, and that would take priority over the interests of devisees. And they might be enforcing a prenup or a divorce decree. So if somebody is still married, but they had a prenup, and that prenup promised the surviving spouse they would be entitled to certain things, that spouse becomes a creditor of the estate and would have priority over everything except for the spousal allowances. Also, a divorce decree. If somebody's already been divorced and there are certain obligations they had under that divorce decree that don't go away at death, then they may be a creditor trying to enforce that divorce decree against the estate. A creditor, while they have priority, have a window of opportunity to make a claim. There's a statute of limitations, and if somebody doesn't make their claim soon enough, then they might lose their chance to make that claim. That statute of limitations in general is a year, but you can shorten that period by publishing a notice to creditors to shorten that down to a 90-day period. Even if somebody were to set up their plan in a way that nothing really passes through probate. So if they were to, for example, name pay on death beneficiaries on all of their accounts, life insurance and retirement accounts, if they were to name joint owners, so everything passed, or they have a fully funded revocable living trust, so they don't have probate assets. If they attempt to disinherit a spouse, if they attempt to not pay a spouse who is a creditor of the estate, a probate can be filed, and the creditor or the surviving spouse can compel the personal representative to go after those non-probate transfers. And they would have up to 2 years to compel the personal representative to do that. So some people have a strategy of, if they never have a probate, they never have to pay their creditors. So they might name pay on death beneficiaries, joint owners. If a creditor wants to make a claim, they can file a probate and they can compel the personal representative to go after those non-probate transfers. The next priority that a spouse would have is to an elective share. So a surviving spouse, unless there is a prenup that says to the contrary, would be entitled to 1/3 of the augmented estate. And for any of you who've read the code pertaining to the augmented estate, it's circular and confusing, and we always hope that a case will settle without having to get into the weeds of it. But when we do, the augmented estate is all of the marital property, all of the collective assets of both the surviving spouse and the decedent. And the surviving spouse is entitled to 1/3 of that augmented estate. And to the extent they already have 1/3 of the augmented estate, then they don't get anything more. If they need to satisfy their share by going after the probate estate or after non-probate transfers, they have the ability to do that. The elective share needs to be made within 9 months of death or 6 months from when the probate's filed, whichever is later. And it's not only effective against probate assets, you can also go after non-probate assets, claiming an elective share. The next in line next priority would be being a surviving joint tenant or a pay on death beneficiary designee. So if you are named as a beneficiary, or if you own an asset jointly and your surviving spouse, you'll receive that asset. There's also plan defaults. If an employer has a default that if no beneficiary is listed, that the spouse is next in line. The federal government is a good example with thrift savings plans, with FEDLI, Federal Employee Group Life Insurance. If somebody has failed to name a beneficiary, then that plan tries to anticipate who the next of kin would be, and the spouse would be next in line. So you could have a spouse making a claim under a plan default. You can have a spouse that is a beneficiary of a trust or is a devisee under the will. And there is a statute for protecting omitted spouses. If you had a will in place and then you marry, there is a provision for including those spouses. What is important in that arena is If somebody has an estate plan in place and they think it's just fine, and then they marry, they may need to re-sign something to assert that they really don't mean to include their spouse any more than what they've agreed to. And then intestate succession, and then survivor benefits under pensions or Social Security. We wanted to jump next into marital agreements, and Amy's going to discuss these with you.
Thanks, Doug. I use the term in this presentation, marital agreements, because it's a blanket term. Most often we're dealing with premarital agreements or prenups more casually. These can also include postnuptial agreements, and keep in mind too that parties may amend their premarital agreements as their life circumstance changes. So marital agreement is that blanket term. So what can they do for people? Well, as we've learned from Doug, they're not just for determining marital property and alimony in the context of a divorce or separation. They can be very helpful estate planning tools as well, for the reasons that Doug has outlined. So you can eliminate, we all kind of remember law school, or if that's your practice, trying to figure out what elective shares are, what all these statutory rights are, can be very complicated, especially when you're dealing with the death of a loved one. So a lot of people will really try to short circuit that and have it be as clean of a process as possible. Moving on to our next slide, marital agreements and estate plans. As Doug indicated, you can waive your right to be a fiduciary. I also include in my agreements that you will not use your status if you become your spouse's guardian or conservator to try to amend or alter or rescind the marital agreement because of that status, just to make sure that if you're acting as a fiduciary, you truly are. Again, you can address statutory allowances such as elective share, intestate succession. We have a link to the code there. And Doug probably deals with this a lot in his practice, where people have to have your certain requirements in a will that has to be witnessed, all the different things in there. For these waivers, you can have them in your marital agreements. They don't have to have the level of detail as you would in a will, but because it's a contract, you do want to have those provisions that are referenced in that code section, that it was voluntary, not coerced. Best practices, I always just double check the code. Better safe than sorry. You can also affirmatively grant your spouse these abilities if you want them to be the fiduciary. A great example is if you have a blended family and you want to make sure that you don't have children from family A and family B, you may want to designate your spouse or a specific person to have that fiduciary role, so that way it ends the discussion. You can also indicate what is your joint property, what is separate property. Particularly, we see this with a lot of blended families. You're creating life estates for your surviving spouse, but ultimately that property would be transferred, either ownership or the beneficial interest, to children or other beneficiaries later.
And this is an area, Amy, where when I am representing a party where I've drafted the I've drafted the prenup and I've omitted the right to anything. So we basically have set up a prenup where my client keeps their separate property and their debts, and the other client does as well, and they don't make a claim against each other's estates. This is a place where we often get pushback from the other side, where often someone has in mind that they don't want to be kicked out of the marital home, that if they're married for a year, sure, I'll waive everything. But if I'm married for 5 years or 10 years or 20 years, then I ought to be entitled to something more. And so sometimes we are affirmatively drafting in significantly more for that surviving spouse than they would be entitled to under any of the statutory allowances.
Right. And that's what I counsel my clients when I'm drafting marital agreements. To put in these baselines, but I always keep in mind that you can be a lot more generous than these defaults are. And using an example from recent pop culture with a famous celebrity divorce, if there is property that was brought into the marriage and there is a move-out provision, as time goes by, children are born, circumstances changes, a 30-day move-out provision can be awfully harsh. again, this is why your marital agreements, just don't sign them and put them in a drawer and pull them out when things start going south. As your circumstances change, remember they can, and in my view, should be amended. So marital agreements in probate. So this is really where divorce law starts dipping into the estate planning world. Typically, we're drafting these marital agreements, and really, if you're a family law attorney, you're probably thinking more, okay, what is separate property? Are we waiving alimony? But keeping in mind, these agreements will someday need to be enforced, and it's not necessarily in the divorce court. The surviving spouse can use the agreement to preserve their claims, but as Doug pointed out, be very mindful of the role that you're in, either as if you're making statutory claims or if you are as a creditor. Those are some really quick deadlines and they come up very fast. A surviving spouse can also use marital agreements to determine what their share of the estate is. Heirs can do that as well, really to determine what is and is not in the probate estate. I've given you links to 2 cases that are on point. The Beasley case, even though it's from 1994, is still strong law. And here's how family law intersects with estate planning. In this case, the spouses signed a prenuptial agreement, basically giving each one half of the assets. They also did a few postnuptial agreements to address specific other property. Interestingly, the moneyed spouse in this case, that the marriage ended in death, but even though it was a multi-million-dollar estate, he did not have an estate plan. So it was determined through intestate law. So really that was the wife versus the statutory heirs trying to figure out what is and is not in the marital estate. So that's an interesting read there, just so you can see how that intersection works. The other case I am citing too is the estate of Uzelak, and there were multiple cases with that. This is the most recent appellate treatment of it, really getting into determining what is and is not in the marital estate, but also a pretty harsh lesson on determining what role the surviving spouse is in and how quickly they need to act, because that really highlights what those deadlines are. Do you have any thoughts on those, Doug, since that's kind of a big intersection into your practice?
Yeah, it presents, some of the worst interactions between clients when you have family members who are fighting the way that a creditor would, and heirs tend to dig in their heels against sometimes their own parent, but also against the step parent.
Marital agreement content. Just a little bit of a primer, both for family lawyers. I know a lot of our estate planning lawyers will do marital agreements as part of planning processes for their client. Again, I am all about following rules and codes, so it's always good to do a refresher if you don't do these often in your practice. See what our marital agreement code allows you to do. Basically, what you can include in your agreements: rights to property, both during the marriage and after. So that obviously addresses what is your separate property, what would be marital property, and again, processes for waiving rights or how to enforce or a limited life estate after. Marital agreements can also address spousal support, life insurance benefits, and choice of law. We do have a lot of mobile families. So again, making sure that the choice of law makes sense for your family, or if there's a possibility that parties might be moving at some point or have property in a community property state. I think that's really essential to determine what laws of what state will be applying to the interpretation, not only of the agreement, but to the extent any property rights need to be determined as well. Waiver of retirement benefits. This is kind of one of those interesting quirks of both family law, estate planning, but also when we're dealing with qualified retirement plans. With a qualified retirement plan, that's going to be pretty much your 401ks, your pensions, those types of things. The presumption is that your spouse is going to be your beneficiary. If that is not what you want to do for various reasons, first have that reflected in your prenuptial agreement. And secondly, after you're married, you need to work with the plan to make sure that you are signing and implementing the appropriate waiver to not have your spouse listed as the presumptive beneficiary. This is something only a spouse has standing to do, so therefore it can only be done after the marriage. So just a good thing to remember there with those little post-agreement punch lists that we have for our clients, making sure that that gets done. And just a tip for folks that don't always practice with marital agreements or in family law, keep in mind some very important things that you cannot include in a marital agreement. And that is relating to, and I'm quoting directly from the statute here, child support, health and medical expenses, medical insurance, child care coverage cannot be affected by a premarital agreement. The theory with that is, and family lawyers are familiar with that, is because the support belongs to the child. I've also seen agreements come across my desk for review where parties have a very detailed parenting plan for children that aren't even born yet. And my personal opinion is that's probably not something that's going to be enforceable. Again, the court is directed to look at the best interest of the child. And I don't think you can really pre-plan for a child who's not even born and we don't know what their needs and the family circumstances might be.
So in planning, contemplating for divorce, I will sometimes get a call from a client who I've never represented before, and they'll say that they're contemplating a divorce. They want to change their estate plan. They want to make sure if they die before this divorce is final, they want to cut somebody out. I also will get calls from people I've represented, and I've represented them jointly, and they've consented to joint representation, and they've waived their attorney-client privilege. And I've told them I can't take sides after they get in a fight. For those clients, send them on their way. They need to get separate counsel. You don't represent them in this matter. But what can be done to change an estate plan but in anticipation of divorce? One option is before you even file, before the opposing party is receives service, you can change your estate plan. So somebody might anticipate filing and change their trustees, change their personal representatives, omit their spouse from their estate plan, change beneficiaries, change joint ownership with right of survivor. After the filing for divorce, though, the only changes that can be made would be changes that don't violate that domestic relations injunction. Do you see this, Amy, as a clear-cut standard, or is there a gray area? You see these more than we do. I simply say, I can't represent you. I represented you jointly, or I say consult with your divorce attorney to make sure we're not violating any of these domestic relations injunctions. But what do you see?
I see that there actually is a bit of gray area with these injunctions because they address a lot of different things, property, children. The one thing that you can't do is change beneficiaries or cancel insurance policies. That's pretty clear cut, but the domestic relations injunction, and I have it hyperlinked here for folks that don't deal with them that often. It's good to see what's involved. It also has an injunction on transferring, encumbering, concealing, or disposing of property. To me, that's a pretty broad definition, and we've only had these injunctions in place now for a little over 3 years, so we really don't have any developed case law on that. To me, I would be very cautious in advising my clients if they are taking things out of a trust estate without their spouse's consent, because you can make all the changes that you want to with spousal consent or court approval. Of doing those things that may seem a little more administrative or just common sense, a part of the pre-planning while the injunction is placed. So caution is the word.
We both wanted to talk a little bit about life insurance, how it comes up in our two different practices. Life insurance is one thing I think is important to remember from an estate planning standpoint is all life insurance is term insurance. All life insurance will terminate if there's not enough money in place to keep that policy going. Some policies are actually called term insurance, where the premium remains exactly the same for that term. And then as soon as that term is up, you can keep the policy going, but the premium goes from a small amount to a very large amount very quickly. If you have a divorce decree that requires keeping life insurance in place, and sometimes that is the only way to really compensate another spouse if they don't have a whole lot of money between them, but one owes the other an obligation. When those term policies expire, it can become a huge burden for the spouse who has to maintain that insurance to keep it going past the term. It's also important to remember that group term life insurance through an employer goes away when you're no longer employed. Sometimes the policies will allow somebody to continue to pay private pay for that to continue, but a lot of them terminate. And if you've negotiated a lifelong obligation to keep a policy in place, and the only life insurance that they have is term policy, by the time that term policy expires, if they try to get a replacement policy, they are going to be much older, they might not be insurable, and it might become an impossibility. I have had clients who are approaching a jump in premium, and they're having to contemplate going back to court to modify a divorce decree. I've also had clients who have passed away, and a ex-spouse has become a creditor of the estate for the full death benefit of a policy that was allowed to expire when somebody retired from their employment. On your side, Amy, when do you negotiate in insurance, and what things do you think about in making insurance a part of the settlement?
It used to be kind of the default. And back when I first started practicing, I would tell my clients that this isn't in the Utah code anywhere, but good luck trying to find a judge who isn't going to order the more moneyed spouse to have an insurance policy in place to secure child support or alimony. These days, we're just not seeing it that often, and really for a lot of the reasons that you bring up, Doug, because if it's a policy through an employment, jobs can change, insurance premiums can go through the roof. And unfortunately, if somebody has let a policy lapse and it's not front of mind for their former spouse, they may not find out that the policy went away long ago until somebody is deceased, and then you're fighting in probate, and again, you're kind of back to where you were fighting
And
over
the awkward
assets.
thing is sometimes they're fighting against their own children.
Yeah.
If the deceased person left everything to their children, and those are the same children of the spouse that has divorced, you might be in a position of trying to fight your adult or minor children for a share of the estate.
Exactly. So that's why it's life insurance. It's great if everyone agrees, but I think there's a lot of minefields there. And in particular, as you touched on earlier, Doug, when beneficiaries are unclear, or when you're dealing with life insurance policies or benefits that could be coming from a federal employee benefit, that's where things really get murky. On our next slide, I point out a very obscure part of the Utah code. And again, I had almost forgotten about that until I was preparing for this presentation and reviewing the case that I'm citing to. There, if you look at this provision of the code, that allows the parties to ask the judge to make very specific findings and include that in your order, that the beneficiaries, as they are as of the time of divorce, will continue onward. So that's kind of going against the default of the marriage statutorily revoking certain statuses. Again, a lot of detail there, and honestly, probably a lot of folks either didn't know about that, or we forget about it often. If there is a conflict regarding who is the proper beneficiary, not all beneficiary statuses are revoked on divorce, and the express term of a policy may actually govern there. And again, with the Hersky case, it determined that the spousal status did revoke the insurance there, but it does go through some helpful exercises, and just to be mindful to update your beneficiary statuses. If you do not intend somebody to be your beneficiary, even if you think their status has been automatically revoked upon divorce. I just tell my clients, like, please just make everyone happy and double check and make sure it's absolutely who you want it to be, even if it seems tedious. Those are essential tasks to be doing post-divorce, or you can wind up forming some really interesting case law, and not many of our clients want to do that.
So the battle has been waged, and the divorce decree is finalized, and everything seems to be over and done. But don't count your chickens before they're hatched. You might be finished with the litigation side of things, and you might have an agreement, but until you actually have money in hand, until you have your assets that are assigned to you, you're still in litigation mode. From my standpoint, from an estate planning standpoint, when we set up a revocable living trust for someone, we help them draft the trust to say what they want. But then step 2 is always we need to transfer the assets to the trust. And so in order to do that, we have to be able to convey real estate. We need to be able to change the ownership of bank accounts. We need to be able to change beneficiary designation on accounts. And if those funds haven't already been transferred to our clients, we don't have a great way of doing that. I had a client come in not so long ago, and he was divorced in 1986. And he had not seen his former spouse since then. And his home still was titled joint tenancy right of survivor. Now, it's important to remember, today we can go to a county recorder's site, we can easily pull deeds. Back in 86, if you wanted to have a copy of the deed, you had to go down to the courthouse, go down to the county recorder's office and pull the deed. And so that was just overlooked. Well, hunting down his former spouse was not easy. We contemplated, should we go to court and have a court order that a deed be conveyed just to him? Finally, we did track down the surviving spouse, and she was willing to sign it. And there was an animosity between them because their marriage had been so long ago, and they hadn't been married all that long. But imagine, having gone through a very hard divorce, having to reopen that a year or 2 or 3 or 4 years later, long after the divorce attorney has given up the case, and then try to get the other party to agree to sign whatever needs to be signed. Things that need to be cleared up is real estate, mortgages, transferring assets, proof of compliance, change of beneficiaries. All of those things can be outstanding matters. And we always like when the divorce attorney handles those and not the estate planning attorney having to handle those.
I couldn't agree more, Doug. I think that really is an essential part of family law, to really keep it in the family law arena, to help your client really tie up those loose ends and fully physically and financially separate from their spouse, or else it can create some very complicating issues in probate litigation. And again, the proof of compliance, I think a lot of things people sometimes may overlook, but it's an important document, is filing a satisfaction of judgment. I recently had a client of a colleague contact me. I was doing some work on something else, like, hey, by the way, my spouse, are trying to refinance, and there's still this judgment on my credit. I didn't even know it was there. How did this come to be? If there's a money amount that's specified in a decree of divorce, that may show up in your client's credit, but if there's not that satisfaction of judgment showing proof of payment or something in the court record that's your lender could see, the county recorder could pick up to say, okay, that's done, this needs to go away. Again, you're right back there potentially chasing down a spouse 10 or 15 years later. If most attorneys don't keep their files much longer than 7 to 8 years, you may not have even an attorney's file to go through. And then it's a lot of work when there was something that you really could have wrapped up right away.
And if somebody really doesn't address estate planning, they kind of just let things go. Sometimes it's through probate that we're having to deal with these. Someone comes forward and says that they haven't been paid, and the family members are absolutely sure they've been paid, but there's not a great paper trail for that, particularly if it's been more than the 7 or how many years people keep their files. Yeah. So we have a few more slides to cover, but we also wanted to take questions. So we'll do the next several slides in the next 5 minutes, and then save 10 to 12 minutes for answering questions, or 8 minutes.
Great. So kind of the catchy topic, death and divorce. What happens when a spouse dies while divorcing? I'm quoting one of my favorite law professors, Deborah 3D. The answer is, it depends. And the answer depends on the status of the case when the spouse died. If the case has been filed, but there are no final orders in place, the court loses jurisdiction and the case will be dismissed. And by final orders, we mean that there's been a court order terminating the status of husband and wife. If that's the case, then property is, if there's no orders in place, the divorce court loses jurisdiction, and then property is determined by the estate plan of the deceased spouse. And I always like to remind people that don't have an estate plan in place. If you think you don't have an estate plan, trust me, you do. That's the laws of intestate succession, which may not be what you want to have happen. If you have a bifurcated divorce, and to translate from legalese there, that means that the issue of the dissolution of marriage has been resolved. The parties are no longer husband and wife. Then the matter can continue to resolve any outstanding issues in the marital estate. Typically, that's going to be property issues. I could also see this being any issues if there were outstanding obligations for child support or alimony, but it's primarily going to be property issues that linger. If a case is pending, it can go on and on and on. The case I'm citing was on your slide here, was decided earlier this year. And I kid you not, this is a divorce case that has been going on for over 10 years. The spouses bifurcated. They were no longer husband and wife, but a very complex marital estate with a lot of litigation involved. And before the final orders on property were entered by the court, one of the spouses passed away, and that raised the question of, does the case continue? Our Court of Appeals clarified our law. Apparently there was some confusion on that. My personal opinion is you always had this right to proceed, but the case goes on. I'm going to try not to sing the song from Titanic. The case will go on. The question remains, though, when, where, and by whom? Utah Rule of Civil Procedure 25 allows parties to notify of death and substitute parties. That can be both the deceased party making this, their state representatives making those claims, or in this case, the surviving spouse. There are time limits on that, so do consult Rule 25. It doesn't necessarily mean that the case goes on in the divorce court, though. If there are obligations that are against a surviving spouse or characterizing property, that's something that could also be addressed in the probate court. I was stalking the docket in the Mauer case. They just recently had a hearing on it, and that was the very issue that they were discussing, whether the divorce court or the probate court should have jurisdiction to wrap up these last property issues. Another case I'm citing for you, and in light of time, it's hyperlink there. You can read all about it. Even though the last names match up, it was actually former wife versus former mother-in-law with some fraudulent transfers. Again, that's a very interesting overlap with family law and estate planning, and we could probably spend an hour just talking about the issues in that case, but we won't.
What I want to leave you with is you can see from these subjects that there is a crossover and a great opportunity for referral. When we are doing prenups, we always have two attorneys involved, so great opportunity to refer to other people. And we always appreciate being able to send a divorce to someone else. I'm never going to do a divorce again. And at the by the same token, we get some of our best referrals from divorce attorneys who say, now that you're divorced, you need to update your estate plan. So it's a great opportunity to work with your colleagues. Why don't we go ahead and take some questions?
Okay, so before we start taking questions, I want everyone to know that I dropped the PDF into the chat. So everyone should be able to see the PDF in chat. Check it out and put in the Q&A if you can't get that PDF. First question. If a couple divorces with minor children, can one or both of the spouses designate guardians for the minor children in a will that are not the other spouse, ex-spouse? Can divorced spouses appoint a guardian to step into their shoes if he or she passes away, or does the guardianship of the children go completely to the other parent if one of the ex-spouses is deceased?
Parental rights are very strong in the state of Utah, and you cannot appoint a guardian in front of the other parent. The other parent, unless their parental rights are terminated or modified, or a court orders a guardianship for some reason, the other parent has the say. And if the one spouse passes away, and then later the other spouse passes away, it's probably going to be that second spouse's designation of guardian that's going to carry, not the first spouse. So it is something that clients bring up all the time, but you can't through a back door undermine that. Now, sometimes we can use money to bribe. You know, sometimes the best arrangement for kids is that they live with one parent and they have visitation with the grandparents and the other side, and that money can facilitate that relationship. And maybe it's best for the child that they be able to still go back and forth between households and everybody gets along, but that doesn't always happen.
I agree with that. I always advise my clients to designate the guardians, but with the understanding the strong presumption is the surviving parent is going to have that presumption, but still it's your opportunity to speak your piece of why you think these other people might be more appropriate guardians. It's a very steep hill to climb, but any person who's interested in the care and custody of a child can petition for their guardianship. But again, that's a huge hill to climb.
So now I'm going to ask the impossible question. When I was practicing, if you were in the middle of a divorce and one of the parties died, the divorce also died. In that instance, if you have an estate plan and a prenuptial agreement that might not necessarily agree with one another, which controls?
That is something that you get to fight out in the probate court. Again, assuming that the divorce wasn't bifurcated, the divorce goes away. But if the prenuptial agreement is a contract, and that's really going to be a subject in the probate court of determining its validity, and that's where the probate court gets to borrow a lot from family law to see, is this a valid and enforceable prenuptial agreement? Because then that would inform what is property subject to the probate estate and not segregated because of the prenuptial agreement.
Yeah, and it does come up more often than you think. There has been more than one time that I've been called to a hospital, someone on their deathbed, their divorce is not final, and the last thing they want is to have everything go to their spouse under their estate plan. So we modify the estate plan. Person passes away, there still is a surviving spouse, and that spouse is entitled to their homestead allowance, family allowance, exempt property allowance, elective share. They might also be a creditor. I've also had cases where the parties had so much debt in common and they had active lawsuits, and you're in this weird position of having a surviving spouse and their attorney litigating a matter that has nothing to do with the marriage, and the deceased person's estate litigating something that had nothing to do with the marriage. So it can get complicated.
So I don't know the answer to this question. I do know that marital agreements have to follow regular contract principles, and they are contracts. Are estate plans considered contracts, or are they a different animal?
We often will draft in as one of the default provisions that this was not a contract, that in entering into this joint trust, the parties do willingly, but there's no contract to make a will, contract to make a trust. But I can't say that it wouldn't be an argument that someone would make given certain facts and certain documents that are in place.
I could also see, and again, I would defer to Doug on this. This kind of comes more into his role too, that again, the court borrowing maybe some contract principles, because I know that happens a lot to interpret divorce decrees and marital agreements, that might also come into interpreting estate planning documents as well.
Yeah. And often estate planning documents, if it's a revocable living trust, you specifically include provisions that either party may revoke it with respect to their own share, which is sort of like we're signing a contract that we can unilaterally terminate at any time. So I wouldn't say that you couldn't use contract law, but there's often provisions in place that make it so it isn't looking strictly at contract law.
So going back to your hypothetical about someone on their deathbed and they want to immediately adjust their estate planning, are there ever arguments regarding competency at the time?
Always. But it's hard. It's hard. Somebody can be on death's door and have legal capacity to execute an estate plan. And sometimes people are very, very sharp right up to the end. And capacity is fluid. You can have good days and bad days. And the hard thing is, it is difficult after the fact, after someone passes away, to litigate competency. It comes down to the facts involved and who was present and how well did you document it and what it was that they were doing and how much did you agree to. It's always a good idea, if you're making small changes, not major changes, to keep the document short and simple. So for example, if you're meeting with somebody whose capacity might be in question, or someone on their deathbed whose capacity shouldn't be questioned, if they are signing a 90-page document, but you've only really modified 2 pages, saying that they understood every page of the 90 pages would be hard. Saying they understood 2 paragraphs might be a little bit easier. Having people present, having recording devices, whether those are admissible, whether that's helpful later. Sometimes we're not talking about what is truly litigated. Sometimes we're talking about showing the other side that this person really did want this. Oftentimes people who get in fights, it's not because they hate each other, it's because they have a disagreement about what their loved one would have wanted or would have done. And sometimes just seeing for themselves that this is what they wanted is enough.
Well, thank you both so much. We're out of time. Before we conclude the program, there are a couple of things I want to go over with you. I will send you your CLE certificates probably before the middle of next week. So watch for those. We will submit your names to the bar, so you don't have to do that. Another thing I want to tell you is I don't normally dress this casually, but I'm advertising for our SBA. Our SBA sells you law gear, and we put the notices when they open the storefront. We put those notices in our monthly email. So make sure you read your monthly email, and you can find the link to get into the SBA store when they open it. And I don't know when that will be, but it will be in their email. Please, if any of you have any questions about the seminar or the CLE certificates or any other follow-up, don't forget to email me, lori.nelson@law.utah.edu. And please join me in thanking Amy Kennedy and Doug Fadel for this very, very amazing program.
Thank you.
Thank you, Lori. It's our pleasure.